He's everywhere. Everywhere, unshakable.
I'm retired.
Right.
Yeah, I just want to make sure I get Matt Abel in here before we start.
I think that's true for any ball player, for anybody. Plus, because you become important in some way that you. I mean, we're all important, but you become important in some other way. You know what I mean?
You know, I think he feels.
Mm-hmm.
I think he's to the people.
Yeah, that's true.
Partners and my employees and all that. It does seem to be genuinely.
You know, before we got to dismissal in that case, he actually offered the prosecutors to plea himself and let everybody else go.
And did they finally dismiss the case?
No, we had to litigate it on our way to a judge. Judge dismissed it on
Judges.
due process grounds. Yeah.
Oh, is that the one that you just talked about?
Sure, before I said it.
No, another one.
And,
No, we've had a couple of.
I'm going to be sitting
That
right
was
in
the clinical relief case out of Ferndale.
Okay.
10, 5, 2,
Yeah.
and stop.
Yeah.
Can you give a quick bio intro before you go?
I'm sitting here somewhere.
And
Clinical relief?
No,
The one in Trent?
no PowerPoint for you, right?
No,
Clinical relief, we just got
You're
it.
sitting right there and you're good
Okay.
to go.
Sorry, just got it in January.
Good.
2 weeks ago.
Let's get started. Great. Great. All right, welcome back for lunch, everybody. Thanks for rejoining us. After a great keynote speech and an excellent morning panel and lunchtime presentation, it's my pleasure to introduce our final panel of the day on legalization and decriminalization of marijuana for medicinal use. Here's how this is going to work. We have just about 2 hours until the conference wraps up at 4 o'clock. We have 4 speakers. I'm going to give each of them about 20 minutes. I'm going to introduce each one at a time, and then they'll have their 20-minute prepared remarks. After the speakers' prepared remarks, I'm going to give each of the speakers a brief opportunity to respond to comments of the other panelists, because I know that we've got some diverse views represented on the panel here. And then we'll open it up to audience questions. Hopefully have enough time to get all the great substantive questions from our excellent audience today. And before I start, I want to echo the thanks that everyone else has offered to the students of the Law Review. I'm the faculty advisor for the Law Review, which is a really fancy way of saying that I do absolutely nothing. It's a student-run journal, and that's never more clear than during a symposium event. The students run the event, the students organize the event, the students put the work into making the event a success, and aside from today, when hopefully they'll get a nice round of applause, it's generally a thankless job. So let's offer them one more round of thanks. Okay, we have 4 panelists today. Neil Rockin.
Close. Rockine.
I'm going to mispronounce
Myself.
every one of the panelists' last names. So that way none of them will take it personally. Neil Rockine from Rockine PC is going to go first, followed by Kevin Sebet. I got that one right. Good, who you heard from earlier. Although during the afternoon panel, he's going to focus his presentation on the medical uses of marijuana. Bill Vertis from the Kitch Law Firm, who's going to talk about the implications of medical marijuana in the medical industry. And then finally, Matt Abel from Cannabis Council is going to discuss not just compliance with the MMA, but the new petition drive to further decriminalize marijuana. So first off, Neil Rockine. Neil is a graduate of this law school, as well as University of Michigan, where he received his undergraduate degree. He's a lifelong trial lawyer, criminal lawyer. He started his career doing prosecution work for the Oakland County Prosecutor's Office before moving over to the defense side with his own firm, where he has a very active, prominent practice defending folks on the wrong side of the criminal justice system involving marijuana. So with that, I'm going to turn over to Neil, and
Thank you.
oh wait, let me get this for you.
Thank you. I only have like 20 minutes, so you just have to tell Noah, don't start the clock running yet. Just so people who aren't law students or lawyers know, Law Review are the smartest and best writers in any particular law school class. I was not a member of Wayne State's Law Review. I wasn't even allowed anywhere near Law Review. In fact, I never had even heard of the Symposium. They didn't even let me go anywhere near it. So I had to thank Law Review for 18 years after finishing law school. Well, actually 18 years after finishing law school that I finally made it to Law Review. So I'm not going to kiss the ground, but I finally made it, I guess. So let me tell you what I'm here to talk about. You've heard, and I'm going to use some analogies and try to have a little fun with our conversation as opposed to what we talked about in the morning session. In the morning, if you think about a war, there are policymakers. And apart from policymakers, there's presidents and people in the Senate. Then there are generals that direct troops to war, but they do it from a cozy, room somewhere. Then there are troops, the, small people that are afraid to go in, that are peeing their pants as they're ready to actually walk into battle. And then there's some grizzled sergeant, from the movie Platoon, who actually has his sleeves rolled up, is dirty, is scarred, has been there before, and has to lead these troops into battle. I'm a sergeant. I actually, unlike policymakers or academicians, I try cases. And I proudly represent medical marijuana patients and caregivers, dispensary owners, and others in the state of Michigan. And so if you were to ask me, say, Neil, on the ground, what is the problem with the Medical Marijuana Act? I would tell you this: the foxes are guarding the hen house. So my topic is, from my perspective, what's wrong with the Medical Marijuana Act is that the foxes are guarding the hen house. Who's watching over the Medical Marijuana Act? We've already heard a lot about how we have an initiative. The initiative was passed, that it was supported overwhelmingly by 63% of the electorate in every county, even Republican counties that have never voted Democratic, voted in favor of the Medical Marijuana Act. So who's implementing it and who's enforcing it? Now, this is an act that you've heard that is supposed to decriminalize or protect patients from criminal prosecution, from arrest, from forfeiture. So who does those things? Who actually makes arrests? Prosecutors, police officers. Who actually makes, who prosecutes? Prosecutors. Who jails? Judges. And I'm going to tell you that the foxes, police officers, prosecutors, and even some members of the judiciary, are the ones that are implementing and enforcing the Medical Marijuana Act. And they're doing it in a way that I will tell you, if you've ever watched a Looney Tunes cartoon, I want you to picture Granny and Sylvester and Tweety Bird, right? And right before Granny leaves the house, she turns to Sylvester and says, "Now, you don't touch Tweety, okay, Sylvester?" And he stands there with his tail, and he's got the halo around his head, and he nods and says, "Okay." And the second the door closes, he makes a mad dash for that cage, and thus the pandemonium ensues. That's what's happened all across the country, in certain states, and it's happening here in Michigan. So who's watching over the Medical Marijuana Act? Not Tommy Chung. It's not Montel Williams. We wish. It's something more like Archie Bunker. And for those who don't remember, Archie Bunker was like the prototypical, 50s, lunch bucket guy who was generally pretty conservative, a bit racist, old school. So what I found is that if you think about who's actually implementing and enforcing the Medical Marijuana Act, it is the opponents of the Medical Marijuana Act. For example, in Arizona, they've had a problem in Arizona. Proposal 203 was passed. Governor Jan Brewer was the lead opposition. Attorney General Tom Horne opposed it. The initiative passed, and then she was left to administer and implement it. What happened in Arizona? You can see Jan Brewer. She looks really happy. She ordered the state to reject all dispensary applications. She and Horne filed a bunch of lawsuits. Then a judge found that she was illegally delaying the implementation of the marijuana law, and her reaction was, "I may appeal." So Arizona has yet to really see dispensaries because the governor has been dragging her feet. New Jersey. New Jersey passed a medical marijuana bill on January 18, 2010. It was signed into law by Governor John Corzine, who was leaving. Governor Chris Christie assumes governorship on January 19th. 2 years later, the New Jersey medical marijuana program still has yet to dispense a single dose of medical marijuana to patients. Governor Christie refused to implement it. He now agrees to implement it, but they don't even have a plan for what the cards are going to look like. They don't even know what the dispensaries are going to be. And Governor Christie said he's not going to force any cities to actually have to allow dispensaries to set up within the city. What about Michigan? Well, you ever heard of this group, Citizens Protecting Michigan's Kids? This was the group that opposed, and they have this big thing you see at the top there, no on Proposal 1. Came up with a catchy name. It says Citizens Protecting Michigan Kids. They were the ones that opposed the initiative all the way through the campaign for the initiative in 2008. These are the people that opposed it, that were supportive of the opposition. Sheriffs, deputy sheriffs, Michigan Association of Chiefs of Police, prosecutors, the Fraternal Order of Police, West Michigan Association of Chiefs of Police, and the Southeastern Michigan Association of Chiefs of Police. Those are the people that were left that are now on the ground that I fight and battle against every day. Those are the people that the citizens, after they voted, turned and figured that they would turn over the Medical Marijuana Act and their initiative to them to enforce. So what about Bill Schuette? Well, he's our Attorney General. That's a handsome picture of him there. So where does Bill Schuette stand in the Medical Marijuana Act? Maybe he's going to protect the patients and enforce the act. Well, that's the actual picture. I cropped the first part. This is the picture of Bill Schuette standing in front of a marijuana dispensing machine that they brought in from California. And that's him in front of the poster that says no on Proposal 1. He led the opposition to Citizens Protecting Michigan's Kids. He led the opposition to the Medical Marijuana Initiative. He's the one who's left that we have to trust to enforce and protect medical marijuana patients. Oh yeah, that's about the promise that he made to us, that he would actually do his job. From my perspective, just like Sylvester, when Granny left, said, don't worry, I won't bother Tweety. Well, let's look at whether Tweety's protected under Schuette's reign as the medical marijuana or as the Attorney General. He sided with federal authorities who sought access to confidential patient records. He issued an Attorney General opinion that declared a part of the Medical Marijuana Act that required police officers return seized medical marijuana to registered qualifying patients preempted by federal law. He intervened in lawsuits brought by prosecutors to support the prosecutors. He intervened in lawsuits brought by a municipality against a dispensary, and he intervened in lawsuits brought by patients against the patients. If he were Sylvester, Tweety would be no more. These are the changes he wants to make to the Medical Marijuana Act. See how you like these. Require homeless patients to specify the village, city, or township where he will most of the time spend the majority of his time. Excuse me, what park bench were you at? You said you'd be in Bell Park and you're over in that other park. Identify in an application the address where marijuana plants will be kept. Identify in an application the address where usable marijuana will be kept. You have to actually, if you, under his bill, if you're a patient and you take a card, you have given implied consent by the patient or caregiver for the department to conduct warrantless searches of your home or business. And he wants, within 48 hours of your registering as a patient, for the police to put your name and address and that information on the Law Enforcement Information Network, right next to people who have criminal convictions and or have warrants. Maybe Senator Rick Jones will protect us. He's the Michigan Senate Judiciary Committee chairman. Handsome picture of him there too. That looks like a real legitimate smile. Well, this is his background. 33 years of law enforcement. He was a sheriff, a captain, a lieutenant, a sergeant, a deputy. He even announces on his website that he has FBI training and that he actually has U.S. Department of Justice training, whatever the heck that is. Oh, and if you thought he was going to protect you from Bill Schuette, there he is next to a sheriff standing right two persons over from Bill Schuette when Bill Schuette announced his plans to radically modify, and I would even say destroy, the Medical Marijuana Act. He's proposing all of Schuette's bills to the Senate. Maybe he has the temperament to overlook, you know, the kind of legislative government temperament where he'll maybe be able to look past his personal feelings about law enforcement and do the right thing. Well, he actually made these comments. These are actually things that you can documented. He actually did a Facebook post to someone named Joan Fabiano, who was an analyst, where he says, "I hear you are taking head meds. Is that true?" And then to a woman who was a lobbyist, he made this comment to the press: "As an elected senator, I'm honored to fight on behalf of my constituents for the best public policy. Unfortunately, Kelly, like a hooker, works for whichever client hires her." This is the man that is the head of the Senate Judiciary Committee in Michigan, who will be presiding over hearings on Bill Schuette's proposed changes to the Medical Marijuana Act. How about the judiciary? Maybe they'll protect us. The Michigan Court of Appeals has a number of judges. I attempted to look at the medical marijuana opinion. Again, you've got some very big brains in this room, some who talked this morning. I'm honored to even share the same podium with Professor Sedler, who stalked me all during his conflicts of law class at 8 in the morning. And there are bigger brains than me to analyze this, but my basic analysis as a trial lawyer has showed me this, that if you look at the background of the Michigan Court of Appeals judges who've decided the medical marijuana opinions, there seems to be a pattern that kind of emerges. And the pattern appears to me to be this, that on at least one of every panel of the medical marijuana opinions, from the Redden case all the way to the most recent, at least one Court of Appeals judge had prior government experience as a lawyer, either as a prosecutor, working for a municipal defense law firm, or working for John Engler, which to me is maybe worse than the other two. But on almost all of the panels, there's at least one, and on the majority of them, there are two. Which means that every time a medical marijuana patient or caregiver, or a case involving medical marijuana patients or caregivers, goes before the Court of Appeals, you have judges whose background is in law enforcement or government defense that is actually deciding the case, all of whom had their experience before medical marijuana was even a thought in someone's mind. One judge, a former prosecutor, actually has somehow found his way onto 4 of the cases. And that judge has gone around and had training sessions with other trial court judges on how to interpret the Medical Marijuana Act. It's even gotten this bad. The mechanism by which lawyers or citizens can seek a court's declaration of their rights is called a declaratory judgment action or declaratory action in court. Some of the most important decisions ever have been declaratory actions. Roe versus Wade, we all know about that case. DC versus Heller that talked about Second Amendment rights. Epperson versus Arkansas, the Scopes Monkey trial case. Bowers versus Hart. Well, in a case that I know about, the Livonia versus Lott case also involved the cities of Bloomfield Hills and Birmingham. And part of that case got severed and sent back to Oakland County for venue and jurisdictional purposes. And the judge in Oakland County decided that even though there are people who live in Bloomfield Hills and Birmingham that are going to be affected by who have medical marijuana cards or patients or are caregivers, and that the cities, Birmingham and Bloomfield Hills, prohibited any act that was inconsistent with federal law, which thus creates a real conflict, like a patient would want to know, can I use marijuana in Birmingham? Can I grow marijuana in Bloomfield Hills? Those patients went to court. And the judge in Oakland Court looked at it and said, declaratory judgment is not appropriate. No one's been arrested or prosecuted yet. So apparently you have to be arrested or prosecuted in Michigan in order to decide whether or not whether a judge will issue declaratory relief. Now you and I both know this, that if it were an insurance company and a law was passed and they wanted to pursue a declaratory action to decide if they had to cover you or you, Professor Sedler, in an automobile accident, they sure as heck would get their chance in their day in court to have their rights declared in front of a judge. What about local officials? Local officials are, unfortunately, in many cases, no better. I live in Bloomfield Township. I have filed on behalf of an anonymous patient who lives in Bloomfield Township a lawsuit against Bloomfield Township. I actually went out and sued my own township to protect the rights of patients. Bloomfield Township passed a law, an ordinance, that prohibits the manufacture and cultivation of marijuana in your home. And, believe it or not, requires that you actually, as a patient, have to register with the police department. Let me repeat that. You have to go down to the police department and register with them that you're a patient. Now, this is the same, many of you may not know this, but in different counties, they have multi-jurisdictional law enforcement units that have both DEA and members of local police departments and sheriff's departments. Bloomfield Township participates in a multi-jurisdictional task force. So you have to walk in and trust when you say, Officer Smith, I'm a patient. I live at 121 Elm Street. And then he walks back and he has to put it in some confidential file somewhere that his fellow officer that he's known for 30 years, who happens to be working with a drug enforcement team, won't have access to. And if you believe that, then I've got a bridge to sell you. They even went so far to promote their law to have a propaganda video. If you want to see it, go watch it. It is scary. They have the supervisor of the township sit down with a police captain, and they talk about how the rights of officers need to be protected. They show officers with masks and guns and vests and raid gear. And the scariest part of it is that the officer who actually says this, he says, well, we need to know if people, before we go into a home, are patients or caregivers. Because we might actually investigate for 2 weeks, kick in someone's door, and then they show us a card and find out that they're innocent. Shocking. How awful to find out that you actually investigated someone who was innocent and then would have to let them go. Royal Oak even has, I think he left, he's not here anymore, but Royal Oak actually had a commissioner who was a prosecutor who worked in the prosecutor's office with me. People say, Neil, how could you have been a prosecutor? And I say, everybody has sinned once in their life. But he was a prosecutor, and he was a drug prosecutor. And he very vocally has expressed his opposition to the Medical Marijuana Act. And in a discussion that you can watch on television, I took part in it. I believe Rick Thompson also took part in it. It was a discussion, a town hall meeting about medical marijuana. A veteran stood up, and the veteran said that he used medical marijuana to help him sleep at night and to not have awful, fitful dreams that would harm his spouse. And to that Royal Oak commissioner said, well, we all know a good drug user. These are the people who are opposing, I should say, strike that, implementing the Medical Marijuana Act. So what's my experience? That handsome guy there, that's me. Yeah, I know, hard to believe. So what's my experience? I was a prosecutor from 1993 to 1997. I've been a defense lawyer now for about 15 years. I am a trial lawyer, so I don't do any of the smart stuff. I just do the talking. Okay? I talk fast, I talk slow, I talk with my hands. But I am now defending cases against the same prosecutors and often cross-examining the same police officers and who are oftentimes using the very same tactics that they used when I was a prosecutor. That's 18 years ago. So for 18 years, law enforcement was doing something a certain way. And for 18 years, they did it a certain way, and they still have the same people who are still doing it. So if you want to know what I see on the road and what I see on the ground is essentially patients and caregivers who are not getting the benefit of the Medical Marijuana Act. The initiative says that patients are to be allowed to advance a medical use defense in any prosecution involving marijuana. That's not happening. I'm a trial lawyer, believe me. I try as hard as I can to get to a jury. All I want is a jury to decide my cases. I don't want any judges. I don't need any courts of appeals. All I want is just 12 people, 6 people, put them in a box, let me talk to them, and let me make my case. That is not happening in Michigan. And if you were to ask the people that drafted this initiative, the folks from MPP, I bet you to a man and woman, to honor Karen, they would tell you that that is not how they expected the law to be implemented. So what do I foresee for the future? What do I hope happens? I would hope that anybody here who happens to live in Michigan, live in a particular city or particular county, go to a city council meeting. They have an open mic session, a general comment session every city council meeting. Get up to the mic, tap into it, say hi, I'm Neil Rockine, I live at 121 Elm Street. I'd like each of you to tell me what your views are on the Medical Marijuana Act and why you're using my tax dollars to not implement it. And if you do that, you might actually find out whether you should vote for the suckers. And if you do vote for them again, then you're the sucker. So anyway, that's my pitch. It's my chance to speak to you. Hopefully it was entertaining. So anyway, thank you very much.
Thanks, Neil. That was fantastic. Our next speaker is Kevin, returning for a second session. He already got a little bit of an introduction. I just wanted to add a couple things. Kevin has, I guess, the honor of being the non-lawyer on this panel. He has a bachelor's in political science from University of California at Berkeley, as well as his PhD from Oxford University. The thing that caught my attention most, though, about Kevin's biography, and I thought this was pretty interesting, is as you learned at the first panel, he was a senior advisor in the White House Office of National Drug Control Policy. He is actually the only person in that office who served under both Democrat and Republican presidential administrations. So for better or for worse, the White House drug policy, at least the current policy, seems to be rather bipartisan. It seems to be one area that both parties agree on. With that, I'm going to turn it over to Kevin. Let me pull up your PowerPoint.
Thanks, Tom. Appreciate it. Thanks, everybody, and for bearing with hearing my voice again from earlier. I enjoyed the discussion, and we'll enjoy having a further discussion on this, but sort of more focusing on marijuana as medicine, really from a policy and scientific perspective, more overall, rather than specific here to Michigan. In a nutshell, when I'm asked, is marijuana medicine, I mean, the answer is really yes, no, and maybe. All together. First, yes, it is. Some component of the plants are, and they're already classified as medicine. They're prescribable today. One of them is called, the trade name is Marinol. I'll talk a little bit more about Marinol later. The other one is Sesamit. The FDA and every other medical scientific body in the world has determined also that the whole marijuana plant, all of its different constituents and components, its cannabinoids, its terpenes, all the different components together is not. There are thousands of unknown, of course, and carcinogenic components that have not been accepted by the FDA. And the maybe part of that is right now there is a robust research effort, a global research effort, partially here in the United States, but also in the UK, Europe, the Middle East, Israel, other places, that are looking into the constituents within the marijuana plant that may actually be approved in the future. Right now, one of those constituents we heard earlier a little bit about it is called cannabidiol, or CBD. This is an exciting area of science that we're just learning about as we learn that our own bodies, as I said earlier, our own bodies and brains produce a similar, we have these receptors, these cannabinoid receptors, which means that our bodies even produce a naturally occurring substance that binds to marijuana when it is consumed in its form. Just to go back, so that's sort of the overall, and then just to talk a little bit about the current status of federal law, we talked a little bit earlier about what scheduling means. So Schedule I drug, meaning that it has a high potential for abuse, no accepted medical use, and that it lacks accepted safety for use, even under medical supervision. And so, clearly that means that it is, for example, the high potential for abuse comes from the well-established public health literature about the dependence-inducing effects for some people on marijuana, and the fact that as a whole plant, it doesn't have the medical use. Similar when we're talking about opium as a whole plant versus the components of opium or the synthetic components of opium. So morphine and other things that are part of the opium poppy and opium plant, but are not the whole opium plant itself. So that's the difference. The FDA has reviewed this a number of times, and of course every time it's reviewed, they're asked to review it again mainly by activist groups. So actually in 2011, they just released over 300-page body of work on what they call the 8-factor analysis of looking at the different studies that are about marijuana. In 2006, they released a statement accompanying their other review that I won't repeat here, but essentially saying that no sound scientific studies support the medical use of marijuana. The way that scheduling works in the U.S. and the way that the FDA and with HHS and DEA interacts is often a point of discussion and I think confusion. The FDA has the final authority on the down scheduling of drugs, so if a drug should go from 1 to 2 or 2 to 3, et cetera. HHS with its National Institutes of Health, so not just the National Institute on Drug Abuse that many of us have heard about, but other institutes as well, conduct research on the possible therapeutic utility of marijuana-derived medication. And like I just said, in 2011, it reaffirmed the status as Schedule 1 after the 8-factor was published. What kind of, and we talked, there was sort of some talk about this in the last presentation about, well, what is going on in the world of marijuana-based medication development? I mean, right now there is a single source in the U.S. In fact, under international treaties and UN conventions, the government actually must have a monopoly over the source of any Schedule I controlled substance. So whether talking about marijuana or whatever else, the international treaties that the U.S. has signed and reaffirmed over and over again, multiple administrations, have us bound to this international law. So right now, that place is at the University of Mississippi. Every 5 to 10 years, another place can apply to become that center, but U of Mississippi has taken it. And I'm not going to read everything on the screen. You can read it yourself. There are hundreds of researchers today with the license to study Schedule I drugs, and Schedule I drugs can be studied by people who do obtain the license. Every single researcher that has put forth a research proposal has received permission to study marijuana. So that has filled out the form correctly and it's passed peer review, that they get that permission. And the studies, yes, they talk about the negative, they talk about the harms of marijuana. Of course, that is part of the study that many people study, but they also have, and there are studies today, in fact, I'm going to be writing something on this soon about laying out specifically what those studies are, because there's a lot of confusion and people think that it's not studied in terms of its beneficial use. There are actually multiple studies going on as we speak, funded by the federal government, that look into that. Now, that may not be something that a Democratic administration will scream out from a rooftop when they're dealing with a Republican Congress that cuts NIH and health funding, but the fact is it is going on, and it has been going on. So the raw marijuana plant, which contains nearly 500 different chemical compounds, is not an FDA-approved medicine. Again, though various components and its related compounds can be and are. So today, dronabinol is what we call Marinol. It's a synthetically produced compound that is like THC, which is the most active ingredient in marijuana that we know about. And there's even another medicine, which is a Schedule II, called Sesamit, and that contains an active ingredient that is a mimic of the chemical structure of THC. So those are the two drugs on the market today. And there are pros and cons of those drugs. In fact, an earlier speaker in his defense was saying it's not actually, these are not drugs that are often prescribed by doctors, and it's true. Doctors have not found these marijuana-based medications to be superior than other non-marijuana-based drugs for a number of things. I wanted to highlight quickly a snapshot of some promising research I think is very interesting. And this is a drug that's been approved in multiple countries in Europe and also Canada, and including the UK, for the treatment specifically of MS spasticity and neuropathic pain as it relates to cancer. And this is a drug called Sativex. In fact, that's what it looks like there. It's an oral mouth spray, usually under your tongue. And what it contains is interesting. It's an extract which contains the active ingredient that we talked about earlier, THC, with CBD, cannabidiol, together in a 1-to-1 ratio. And so they grow, actually, this company grows whole marijuana in the south of England. So they don't receive their source of marijuana from the US, but they are doing their trials right now in the US. In fact, they're conducting 3 multi-site, multi-country trials. They're in FDA trials here. Phase 3 is, about 80% of drugs in phase 3 will move forward for approval. That's pretty late stage. They've recruited those patients in Europe and also in the US, and they're really dealing with the FDA right now. And they've been going through the process in the US for the past 10 years or so. Obviously, there will have to be a DEA schedule. So similar to today, we have the date rape drug. GHB is a Schedule I drug, but we have a drug based on that called Xyrems that we talked about earlier for narcolepsy, which is a Schedule III drug. So there is a way to sort of split the schedule, even like we have right now as we speak for marijuana and Marinol. There's a split schedule. I'm guessing that would happen if Sativex was approved. That you would have marijuana, the whole plant material, still a Schedule I, but you would have Sativex, which is the 1-to-1 ratio together of those two ingredients. I just want to talk a little bit, moving from the science to the laws that we had talked about, obviously, since '96, there have been 16 states. These really started as more affirmative defense, and then they moved on to what we have now, which is this phenomenon of dispensaries selling marijuana. And in terms of the relation of the Department of Justice, obviously the Department of Justice is charged with enforcing the Controlled Substances Act, which basically says that these drugs are illegal, but there are, for legitimate medical and scientific use, there has to be some availability. So we had heard a little bit earlier about the memo that was in 2009 that the then Deputy Attorney General, David Ogden, released, which basically said, reiterating a policy that was this pro forma also in the Bush administration, that arresting individual patients from a federal U.S. attorney perspective was not a priority of the department. In fact, it's actually very interesting, sort of being on both sides and being nonpartisan on this issue, to look at the sort of similarities and differences between the Obama and Bush administration. There have actually been more raids and more action in the Obama administration versus the Bush administration on commercial marijuana outlets. Now that may be because there have just been more of them since the Obama administration has taken over, but it's an interesting fact. So there was advocates for marijuana and medical marijuana rejoiced at this memo, because I think most of them stopped reading at the line that it would say that these individual patients were not a priority. They forgot to read the rest of it, which basically said, federal government still reserves the right to enforce the law under the Controlled Substances Act, and we're still going to go after commercial operations, people who make money, people who have this mixed up with guns or other illegal things. And so there was an explosion of dispensaries around the country after this memo, because it was sort of, again, taken as, this is what the president said he would do, we're so happy. The Department of Justice released an update to that, which is the current Deputy Attorney General, Jim Cole, which essentially said, oh, wait a minute, we're alarmed at the growth, and there will be action because, you shouldn't sell, under federal law, marijuana, you can't sell it. I'm going to move forward from these. There obviously have been raids. There have been a lot of U.S. attorney letters. So the Melinda Haig letter in the state of Washington, the U.S. attorney said that, clarify the government's position for that district, and even said that there are implications on state employees who carry out these laws. There have been multiple letters that we can go on and on. So, I think that the discussion from a federal perspective often has been the water is a little murky, because people sort of read into what they want to read into it, especially about this president, and the reality is marijuana is still a controlled substance as a whole plant, but there's research being done on the individual components. I also wanted to present a little bit on the effects, what we know 15 years later about medical marijuana in states that have been implementing it for quite a while. So it's interesting to look at the literature, to look at who's using medical marijuana, why, and what doctors are using it. I'll move forward. Just an interesting timeline in California. I mean, most people think that 1996 was this big turning point because of Prop 215 in California. And really, California did not see any dispensaries for about 9 years. So, I mean, 96 to 2005, there were these cards that were issued. Some people got them, some didn't. It was more of this affirmative defense, grow your own. It wasn't really a big issue. And then you had the Ogden memo, which was confusing for a lot of folks. You had some city council actions, and you basically had almost 1,000 dispensaries between 2006 and 2009 in Los Angeles alone. More dispensaries than Starbucks, many times 4 on every corner. I mean, this is a money-making machine, obviously. There's a lot of money to be made in this, and many people have made money. And in that time, the city council, many of which were in favor of medical marijuana, did not like what they were seeing. They closed some loopholes and closed some laws. Right now, it's still kind of in flux, but the number has been reduced dramatically from almost 1,000 to about less than 300. But again, what's interesting is to look at when, there have been all these dispensaries and people applying for these. Who are these people that are asking for medical marijuana? Well, the California profile, if you look at a sort of meta-analysis of about 10,000 users in the last, and really in the 2000s, found that, and this was actually produced in a journal called the Harm Reduction Journal by two self-confessed advocates of both medical marijuana and legalization. And so they looked at what are the demographics of folks who use medical marijuana. Basically, it was 98% of those who used it reported the use for soft tissue damage, so pain, back pain generally, not the cancer, MS, glaucoma, AIDS, illnesses that you had heard about, I think, during the campaign. 70% of them are under the age of 40, and a very interesting thing is that by far the vast majority of the activity in these dispensaries are happening on weekends. Friday 2 p.m. to about Sunday at noon is apparently the best time to get your medicine, and also primarily foot traffic. So this individual profile, for example, of 4,000 applicants showed that the average age of the user was, really the profile was a 32-year-old white male, history of alcohol and drug abuse, no history of cancer, AIDS, glaucoma, or MS spasticity. Over 65% of them had self-reported that they had used cocaine in their lifetime. And then you go down to the 3.5% disabled, 3.4% retirees. You had 17% that had used heroin and 53% that had used methamphetamine. So, interesting drug profile there. Oregon, you can also look at it was interesting to look at who's actually dispensing this in Oregon, what kind of doctors are doing this. Turns out that it's really that 10 physicians are making about half of the recommendations in Oregon. So there are 50,000 registered individuals that can get recommendations, and there are about 10 physicians that are responsible for half of them, and also 40 people that are under 18. Colorado is very similar. You have basically the 3 or 4 smallest pie slices in the pie chart are for HIV, AIDS, glaucoma, and cancer, and the rest are for self-defined severe pain and muscle spasms. An interesting thing also about the AIDS community is that, the AIDS community was one of the primary communities that were in favor of medical marijuana during California's run in Prop 215 in 1996. They've been silent recently, in fact, not really taking major positions. And that really is because the ailment that AIDS patients had used marijuana for, so the Kaposi sarcoma and the wasting, is virtually eliminated today with the antiretroviral cocktail. So if and that wasn't available in 1996. So if you adhere to the cocktail, which has been remarkably successful, a wonderful advancement of science in the last 15 years, adherence to that cocktail has made Kaposi sarcoma and AIDS wasting virtually a non-issue in AIDS patients for those that comply with their medication. There are those that don't take the cocktail for various reasons. But so that's actually probably one of the reasons scientists have looked at this, and HIV patients barely register on the screen is for that. So that isn't necessarily to downplay the effects of muscle spasms or severe pain that you self-describe. But I think the overall issue is that, clearly there are medical properties of marijuana. No one is saying that every single person who says that they feel better when they take marijuana is a liar. I'm certainly not saying that. Nor would I say that the person who is smoking opium to get the beneficial effects of the opium plant, which include the anti-pain effects of morphine and things that are already synthesized today, nor would I say those people are liars. But modern medicine is that we've isolated one or multiple components of these naturally occurring plants and these drugs that are, these substances that are in society. We've isolated them, we deliver them in a safe way. Smoking is not an effective delivery system. We can talk about vaporizers, and I think the science has not caught up yet with the discussion about vaporizers in some communities, but we can talk about that. We can talk about the tinctures and the other more accepted delivery systems of marijuana. But the bottom line is willow bark is a plant, and that's where we derive aspirin from. We're not asking people to chew willow bark to get the effects of aspirin, nor smoke opium to get the effects of morphine. I think the argument is similar with marijuana, that there are medical properties of marijuana, but to smoke marijuana to get those properties really is contrary to the science, and is why, as a whole plant, I don't envision a rescheduling of marijuana as a plant from Schedule 1 because of the unstableness of smoking, the harsh delivery system. The Institute of Medicine looked at this in 1999. These were scientists only, and no politicians, and not a governor's commission from 40 years ago, an actual scientific blue ribbon panel, and who basically said, you know, clearly there are people who receive beneficial effects. Those people should be put in scientific trials, closely monitored, you know, less than 6 months in hospitals with doctors. But the idea that they would be going to a dispensary by people that are not doctors, and by people that give recommendations out if you have $200 cash, is not really the way to do medicine. So I would argue that I don't think individual patients should be arrested. And if they are, that no, I think that's wrong. But at the same time, we should speed up the medical research into the individual components of marijuana and do it like we do any other medicine. We don't vote on medicine. We let the scientific process decide. So, thank you.
Thanks, Kevin. Fantastic. Our next speaker is Bill Vertis, partner at the Kitch Law Firm. Bill's practice focuses on advising healthcare organizations, physician groups, state and local authorities with compliance with the Michigan Medical Marijuana Act. Bill is a graduate of Michigan State University and University of Notre Dame Law School. Let me pull up his presentation.
Good afternoon, everyone. Thank you, Professor Hall. Thank you to the Wayne State University Law School, and particularly thank you for all of you for coming today, staying today, and most importantly, choosing us over going to see the President in Ann Arbor. By show of hands, how many people have read a newspaper in the last 3 years? So you know that there's been a lot of publicity on the MMMA, on its effect on patients, on its effect on caregivers, business owners, dispensaries, entrepreneurs, lots of other aspects. What I'd like to address today and focus on is an area that's been largely under the radar, and that's the effect of the MMA on healthcare providers and ultimately the healthcare community in Michigan. My law firm is known primarily as a healthcare law firm. We do all areas of law, but what we found out is that this area actually came to us rather than us seeking it out. Once the act was passed, we got calls from clients in every one of the areas that we do business in. We got calls from business owners. We got calls from municipalities, from insurance companies, from employers. But as importantly, we got calls from doctors and healthcare facilities saying, what is this, and what do we do about it? I am not a proponent nor an opponent, so my address today really goes to how this affects healthcare providers. It is essentially, first and foremost, a healthcare law and a healthcare issue, and what the various protections and various perils of the law may be. Before we analyze those protections and the different perils to the healthcare providers, the first step is to look at the Act itself and see what it says. It does provide detailed protections to healthcare providers. It says a physician shall not be subject to arrest, prosecution, penalty in any manner, denied any right or privilege, including not limited to civil penalty or disciplinary action by the Michigan Board of Medicine, Professional Licensing Board, or Bureau. At first blush, that appears to be very broad protection. But as we will see as we go through the analysis, those protections are not unlimited. First of all, they apply only if the providers specifically comply with the specific language of the statute. And as we've seen in Michigan, the trend in the court decisions and the approaches by the municipalities and law enforcement is to try to construe the statute and the protections in the statute very, very strictly. So we've seen cases in employment law, in business development, dispensaries, criminal law certainly, that have said This only protects what it protects, and anyone that steps outside the four corners of the statute is not going to be protected. The argument has been this. There's a wide misperception that this act legalizes marijuana. It doesn't. It doesn't make marijuana legal in Michigan. There's laws on the books that pre-existed this act that said it was illegal. Those laws still exist. It doesn't create a protective class of citizens or patients that are immune from prosecution for what was otherwise illegal. The consistent view of the prosecutors, at least, and to a large extent the court, is that this doesn't legalize marijuana. What it does, at best, is protect people from prosecution for doing what was and is still an illegal activity. When viewed in that way, it's not the get-out-of-jail-free card that many people thought it was at the very beginning. Currently, the statute protects physicians only in terms of what the physicians do or don't. What I mean by that, a physician is defined as individual licensed under the health code as a medical doctor or a doctor of osteopathy. It doesn't protect other healthcare providers, chiropractors, podiatrists, holistic medicine practitioners, or the general public. There are implied extensions to offer protection to other healthcare providers, and we will talk about that in a bit, but the strict interpretation of this statute is that only physicians have explicit coverage and protection under that particular section of the statute. Not only is it limited to doctors of medicine and osteopathy, but the scope of the practice is also limited. Under this act, it's important to understand what doctors are and, more importantly, are not allowed to do. The statute says that the physicians are not subject to arrest or discipline solely for providing written certifications or otherwise stating the palliative or therapeutic benefit of the medicine. So it's important to understand that the doctors do under the statute what doctors do traditionally, and that is examine patients and diagnose them with medical conditions. That's it. That's what the doctor's function always has been. That's still what it is under the statute. The process for the physician involvement is they are the first step in the patient obtaining a certification. In order to even apply for a certification, a patient has to go to a doctor, and the doctor has to sign a certification that states the patient's debilitating medical condition and indicates in the doctor's opinion that the patient is likely to receive therapeutic or palliative benefit. It's important, and we've heard about this today, but I can't stress this enough, doctors can't prescribe marijuana. It's a Schedule I controlled substance. We've heard all about that. But I find it a bit ironic when we're talking about medical marijuana that marijuana by definition is a substance that has no currently accepted medical use and treatment in the United States. And to the extent that it's medicine, it's certainly a unique medicine in that it's the only medicine I'm aware of that a doctor can't prescribe, they can't dose, they can't tell you how to use it, they can't tell you how much to use, they can't tell you when to take it, they can't tell you how often to take it, they can't tell if it works by any scientifically accepted test. They can't even tell you where to get it. And the running joke from the MDCH, which was the initial part of the government of Michigan that was responsible for administrating the act, they were flooded with calls once the act passed and said, okay, now it's legal, right? Where do I get it? And their stock line was, just get it where you always got it. And so, when it's just an interesting thing when we start talking about medical marijuana. In order for the physicians and healthcare providers to have protection under the law, I can get my button to work, care must be provided in the course of a bona fide physician-patient relationship. Currently, what constitutes a bona fide patient-physician relationship is not defined. Over the past year, we've seen an instance where a doctor in Macomb County had her license suspended by the Department of Licensing and Regulatory Affairs. What she was doing was having pre-signed certifications without seeing patients, which were being sold in the back of an appliance store. Now, while we in Michigan don't know what a bona fide patient-physician relationship is, I'm pretty sure that's not it. There is legislation being proposed currently by Senator Jones and others. I will talk about that in a bit. But right now, as it stands, you're protected if you only have you're only protected if you have a bona fide patient-physician relationship. We're not sure exactly what the scope of that means. In order to get protection, the physician's got to provide a full assessment of a patient's qualified medical history or state that in the physician's professional opinion that the patient's likely to receive therapeutic or palliative benefit. So what this means is that a doctor, in order to comply with the statute, has to, at the very minimum, do a full assessment of the history. Or does he? This says full assessment or the doctor must complete a full assessment of the qualifying patient's medical history or for otherwise stating that in the physician's professional opinion, a patient's likely to receive therapeutic or palliative benefit. Arguably, a physician doesn't even have to examine the patient or take a medical history in order to sign the certification. While many of the proponents and patients have cited that as being a very flexible and good provision, the doctors aren't so sure. And it might actually be counterproductive for reasons I'll talk about in a bit. Despite the protections that are set forth in the statute, a physician still can be sanctioned if the physician fails to properly evaluate the patient's medical condition or otherwise violates the standard of care for evaluating medical conditions. So that's what the statute protects. But I would suggest and submit that the protections are not only limited, but dubious in certain respects. First of all, I told you before that the strict reading of the statute protects only DOs and MDs. However, there is another provision in the statute that talks about other protections that may be applicable to other healthcare providers. A different section, 333-26424I says, a person shall not be subject to arrest, prosecution, etc., solely for being in the presence or vicinity of medical use of marijuana in accordance with this act, or for assisting a registered qualifying patient with using or administering marijuana. When you look at the legal definition in the statute of what constitutes use, it's real broad, and I won't spend our time here today talking about that, but it's more than just using it. It involves things like transporting and delivering and et cetera. So the medical use is widely defined. Since this applies to persons, arguably this would provide some protection to people who aren't MDs or DOs. The bona fide patient-physician relationship. In order to enjoy the protection under the statute, there has to be this relationship, but as I said earlier, it's not been defined. And currently, there are no requirements that a physician have seen the patient before, no requirements for prior care. There's no requirement that the doctor do a physical examination. There's no requirement that the doctor review records from other patients. There's no requirement that the doctor keep records. And the problem that has been voiced by municipalities and the prosecutors is that what this has spawned are certification mills. Clinics where patients will come in and submit some money, talk to the doctor a bit, and walk out with their certification. this is my editorial comment on that from the healthcare community's perspective, is that I don't, personally I don't care if they do or they don't do that, but it's interesting to me that the statute requires as its first step to get a physician involved, and without this description or understanding of what a bona fide relationship is, it makes you wonder why. Why do you need that doctor involved if they don't really have to do most things that are commonly accepted medical practices? If the goal is to get credibility or the goal is to add some validity to the certifications, it would seem to me counterproductive to not put some teeth into this or some explanation and some parameters as to what this relationship is. It would seem that all would welcome some stricter standards just so the physicians, number one, feel that they are doing their job as physicians and give the general public protection, some sense that there aren't just certifications for hire. The doctor also has got to determine the likely therapeutic and palliative benefit of marijuana use. But that's not clear either because there's no testing required in order to get a certification. There's no requirement that the doctor do any follow-up care or assessment. There's no existing standards for assessment. Primarily, the doctor says this works because the patient tells me it works. There's nothing wrong with that in the abstract, but doctors are used to dealing with scientific evidence, with scientific proof, with tests to test the accuracy of the medicine or the effectiveness of the medicine. Some of this isn't the doctor's fault. Part of it is they're hampered by the fact that there hasn't been a big body of science for the reasons that we've talked about. It's a Schedule I drug, and there are limits to what is allowed and what is not allowed to be tested. Maybe that will be changed now that 16 states have some form of medical marijuana on the books, but right now the doctors don't really have a good body of science that can say, this will be my test to evaluate whether this is working or it's not. I said earlier that doctors have protections, but they're not immune, and there are certain limits to protections. As I said, doctors can be nothing about the compliance prevents them from being sanctioned if they fail to properly evaluate a patient's medical condition or otherwise violate the standard of care. The difficulty with this concept when we apply it to the medical marijuana statute is that this language has certainly had a major chilling effect on physicians' willingness to become involved in the process in Michigan, because this concept of standard of care, if you can be sanctioned for violating the standard of care. A large part of my practice is defending doctors in medical malpractice cases, and they're often charged with violating the standard of care. The standard of care is defined in the Michigan statutes as what a physician of ordinary training and skill would do in the same or similar circumstances. To testify in a medical malpractice case, an expert has to practice in the same or similar specialty as the accused physician, and if that accused physician is board certified, the expert also has to be board certified in the same certification. I didn't check today, but the last time I did check, there was no board certification as a medical marijuanaist, and therefore, since any doctor, any MD, or any DO of any medical specialty can sign a certification, the question becomes what standard of care, who determines the standard of care, who determines what actions violate the standard of care. Is the standard of care for evaluating a medical marijuana patient the same for a family practitioner as it would be for a pain management specialist, or an anesthesiologist, or a neurologist? We don't know. What does it mean to properly evaluate the patient? We don't know. What constitutes a proper evaluation is kind of in the eye of the beholder when you think about a neurologic evaluation. That what constitutes a proper neurologic evaluation differs completely. If you're talking about one done by an emergency physician who's seeing a patient for the first time versus their internist who may be treating them over a course of time, or a neurologist who may be seeing them on a specific referral for a particular neurologic condition. What is proper for one may not be proper for the next. Debilitating conditions under the statute range from cancer to glaucoma to AIDS and a whole list of others. Typically, when those evaluations of those patients are done, they're done by a specialist or somebody familiar with that particular disease or disease process. They're normally done by different specialists in different disciplines. And what we're left with, if we don't have a recognized standard of care or even a way of determining who decides the standard of care, is a very subjective standard. And that's the thing that has the physicians scared, because ultimately their licenses are at risk if they are signing certifications and can be brought before the Board of Licensing to pass judgment on their medical judgments. Unfortunately, the common response has been that many physicians have said, I don't want to deal with this, and I'm not going to do it. In the last 3 or 4 months, there was an article in a newspaper that 55 doctors in Michigan have signed 70% of the certifications. Again, nothing wrong with that, but what it does two bad things in my opinion. Number one, it doesn't allow patients to, it doesn't promote physicians' willingness to do this, and it allows opponents to categorize this as kind of a fringe element and kind of devalue the services of the physicians and of the evaluators. Right now, there are 2 bills pending, one in the House, one in the Senate, that would at least give some definition and some parameters to what a bona fide patient-physician relationship is. There are different bills, and I won't spend the time here today discussing the minute details. However, at least the House bill requires that, at a minimum, bona fide physician-patient relationships requires an in-person evaluation. You have to be treating the patient for reasons other than simply providing certifications. You have to maintain records on the patient. There's a reasonable expectation that there will be follow-up care and examination, and you have to notify the primary provider of the treatment that you're providing. In summary, this is, we invoke the participation of physicians in this statute for good reason, and that is, it is a medical issue, and it is medical marijuana. What we don't have in this state is strong parameters allowing those physicians to do their job, and until those parameters are set forth or a body of law is commenced, I'm afraid that more physicians than not are more than willing to just avoid the issue entirely. Thank you.
Thank you, Bill. Finally, last and certainly not least, we have Matt Abel of the Cannabis Council law firm. For those of you who don't know Matt and his work, he's been a prominent criminal defense attorney in Michigan for over 20 years, defending marijuana users under the criminal system. He's a graduate of this law school, and he's also recently probably been spending more of his time trying to reform law than helping clients comply with existing law. He's been one of the leaders behind the proposed ballot initiative to further decriminalize marijuana in Michigan. I'm sure he'll tell you more about that in a moment. So let's welcome Matt.
Thank you very much, Professor. And thank you to the Law School and the Law Review. It's a pleasure to be here, to have this opportunity to be back at my alma mater on the other side of the podium for change. Let me ask, how many law students are in the audience, if I might? Good, wonderful. When I was in law school here, I took constitutional law from Professor Sedler. And you know, one of the things that Professor Sedler taught me was that there had to be a case or controversy. That very old case of Marbury versus Madison I almost slept through the class, but you know, it's a good thing I didn't. I had a case about a year ago where a defendant had come to me. He'd already lost his case in the Court of Appeals and came to me and said, you know, this just isn't right. I want to appeal to the Supreme Court. And I said, well, what happened? He said, well, I was charged with marijuana and felony firearm violations, and there was a search warrant issue, and we were arguing the motion, and the judge dismissed the case, and then the prosecutor appealed, and the Court of Appeals reversed it. And I said, well, you're done, you're cooked, you're going to lose, but you know, here's your choice. You can appeal to the Supreme Court, and it'll take a year and a half for you to lose, or you can just suck it up and go back to trial and try to cut a plea bargain or something. And he said, man, I don't know, I just really want you to look at this case. And so I read the transcript of the motion hearing where he had dismissed the case, the judge had. But what happened was the judge didn't actually dismiss the case. The judge said, the law is thus and such, and I'm going to dismiss this case. And the prosecutor said, can I have a minute, Your Honor? And went back, took a break, and came back and nollie-prossed the case. He dismissed the case. Okay, it was dead. At that point, the Supreme Court had a similar case, similar issue, and they changed the law on that search and seizure issue about a week later. So the prosecutor's like, darn, I could have appealed, right? Well, instead of just refiling the case, which he had the right to do because it had been dismissed without prejudice, so he could refile, instead of doing that, he entered another order behind the back of the then defense attorney, which appeared to dismiss the case on the motion that the judge had ruled on. I mean, it appeared to have allowed it to go to the judge and that the judge had dismissed it on motion. So I got pretty excited. I went and I read the transcript and I found the part where he said, and Your Honor, we're just going to nollie-pross the case. So I'm like, wait a minute, Professor Sedler taught me this. You can't appeal a case if there is no case or controversy. So what I learned at Wayne State Law School allowed me to cite one of the earliest cases in constitutional jurisprudence, Marbury versus Madison, and I won the case. The Supreme Court reversed and said there was no case or controversy. This is a dead case, and it remains so today. And by the way, they've amended the court rules now to allow automatic stays in the case of an interlocutory appeal, because that was what tied the prosecutor's hands. So not only did we win, but we affected the jurisprudence of the state, and really kind of without even trying. So you can do that, and you have to look for those issues. So I'm here to talk with you about the history of the Michigan medical marijuana law, I guess legalization and decriminalization of marijuana for medicinal use. And I've been practicing law in Michigan 25 years. I've always done criminal defense. I've been in general practice for a while, but it always included criminal defense. It always included marijuana cases. I always felt that the laws against marijuana were unconstitutional, but Professor Sedler hasn't figured out the theory for me to run on that one yet. I'm sure he will, though. Give him time. I'm confident. So we've had, what happened was through this litigation, the Court of Appeals has come down with one bad decision after another. And I'm not going to mention them all to you, but let me just give you a couple of the highlights. The first case I had was a guy named Keith Campbell who was growing up in Tuscola County. Now, Mr. Campbell got busted before the medical marijuana law passed. But the judge in Carroll, who unfortunately is now retiring, dismissed the case anyway, under our argument that the law said that the affirmative defense applies to any marijuana case. And the judge agreed this was a marijuana case, and so he dismissed it. The prosecutor appealed, and the Court of Appeals reversed that case, holding that the law was not retroactive. And so that began the bad run of cases in the Supreme Court. That was the first one, Campbell. And then I think next came Redden and Clark, which was bad for Redden and Clark because they lost in the Court of Appeals, but the court in that case said there are two avenues of defense. One, the Section 4 registry card provision, and the other, the Section 8 affirmative defense provision. So we thought that was good, except there was a concurrence in there written by Judge O'Connell that tore the law apart. And too many other prosecutors and courts have cited that concurrence. Now, the Court of Appeals is a 3-judge panel in Michigan, and what happened was all 3 judges agreed on the majority holding, and then Judge O'Connell wrote his own concurrence. Now, when you have two that agree and the one that doesn't, I call it a dissent, okay? And I regularly refer to it as the dissent, although it's called a concurrence, but the other two didn't agree with him. So I think that's important to point out to the judges. And so then we had the case of Larry King in Shiawassee County. He was growing outdoors in a dog kennel, another one of my cases. The judge in the district court bound it over. The circuit judge dismissed it, finding that there was a defense, that he had an affirmative, that the facility was locked, but even if it wasn't, he had an affirmative defense. The King case was also reversed by the Court of Appeals in a crazy decision that even if you agree with the result, it's really hard to follow the reasoning, so I won't even try. The King case, by the way, was appealed to the Michigan Supreme Court. The ACLU is handling it now, and that was heard about 2 weeks ago. 2 weeks ago yesterday, I believe, in the Michigan Supreme Court. In a few months, we'll have some type of a decision on King and the other case they heard at the same time, Kolinek. But those cases don't deal with any of the, what I call the million-dollar issues, the dispensary issues. These are just, what is a patient, what rights does a patient have, what are the defenses for a patient, et cetera. And then we had a terrible case out of Grand Rapids called Bilesma. Ryan Bilesma is a caregiver, or was. He had the right to grow his own 12 plus another 12 plants for another patient for whom he was a caregiver. Well, in addition to those 24 plants, there were another 36 or so plants that belonged to some other caregiver. But as they tell you in law school, bad facts make bad law. And the bad facts in that case was that one of the caregivers testified they'd never even been to the garden. They hadn't been there, so there's no way that they were actually caring for the plants, et cetera. But based upon those facts, the court issued a ruling that said, for all practical purposes, there can be no sharing of grow rooms, that if you are a gardener and your spouse is a gardener as well, and you're both fully loaded and you both have 72 plants, they have to be separate, completely separate, no access from one to the other. As if that isn't crazy enough, Bill Schuette, the Attorney General, then, well, issued an opinion that not only does each caregiver's plants have to be segregated, but that each patient's plants have to be in their own separate enclosed locked facility. There is nothing in the statute where you can even imagine that, and there is no reason why that would follow. But so just to show you, the Attorney General is being even more restrictive than the courts in this case. The Attorney General says the police are not allowed to return medical marijuana to patients. Not all the cops agree because you know, I've had two clients who've had medicine returned to them by the Detroit Police Department and some other agencies, actually. So that's still at issue. And that leads me to get into the meat of this, if you will, which is the doctrine of dual sovereignty and whether the state can have a law different from the federal law. Whether the Federal Controlled Substances Act preempts the Michigan medical marijuana law. There was a judge in Dearborn, Judge Summers, who ruled last year that the Michigan medical marijuana law was unconstitutional and it was preempted. The result of the case was the defendant in that misdemeanor case was not allowed to use the medical marijuana law as defense. The prosecutor didn't appeal it, so there's not going to be any precedential law. Only the Court of Appeals and the Supreme Court make precedential law in Michigan, so there won't be any out of that. But that judge found that there was federal preemption. Now, there's a doctrine of dual sovereignty. We have the federal sovereign and the state sovereigns. And if you take a review of federal preemption statutes, statutes where the federal law preempts the state law, and there are reviews of them. There are hundreds of statutes, and you can get a list of them. They're all civil or administrative type cases. There are no criminal cases that are preempted by federal law. So how is it now that this one is the exception, the medical marijuana law? Well, the answer is it's not the exception, and the judge got it wrong. And as some type of argument there, I want to point out federal law, 21 U.S.C. Section 903. It's in the Food and Drug Statutes the Drug Abuse Prevention and Control Act under Control and Enforcement. Section 903, Application of State Law. No provision of this subchapter shall be construed as indicating an intent on the part of Congress to occupy the field in which that provision operates, including criminal penalties, to the exclusion of any state law on the same subject matter which would otherwise be within the authority of the state, unless there's a positive conflict between that provision of this subchapter and that state law so that the two cannot consistently stand together. This is part of the Federal Controlled Substances Act. Specifically says we're not preempting state law. So to further hammer that home, there's a U.S. Supreme Court case, United States versus Lanza, 1922. It's appropriate because Lanza's a prohibition case. Mr. Lanza was a bootlegger, perhaps. And the court said, we have here two sovereigns deriving power from different sources, capable of dealing with the same subject matter within the same territory. Each may, without interference to the other, enact laws to secure prohibition with the limitation that no legislation can give validity to acts prohibited by the amendment. Each government, in determining what shall be an offense against the peace and dignity, is exercising its own sovereignty, not that of the other. And then later in 1985, in a case called Heath versus Alabama, the Supreme Court of the United States said, it's axiomatic that in America, the powers of sovereignty are divided between the government of the Union and those of the states. They are each sovereign with respect to the objects committed to it, and neither sovereign with respect to the objects committed to the other. And this cites an old case, McCulloch versus Maryland, 1819. Another oldie but goodie. So I think it's clear here that there is no federal supremacy and no preemption in this area of law. I want to talk about the ballot proposal, but just a couple of comments in response to well, some of the other things I heard today. Sativex or Sativex, the oral spray, it's interesting because it's a cannabis extract. And they've actually found that perhaps people suffering from marijuana withdrawal, which is not physically addictive, but perhaps psychologically addictive, might cause people anxiety or sleeplessness. And people who don't have cannabis might have anxiety or sleeplessness. So they have found a pharmaceutical preparation that works for anxiety and sleeplessness. And you know what it is? It's Sativex. Marijuana will cure marijuana withdrawal. Amazing, isn't it? Yeah. So really here, some people say smoking is not an effective delivery device. I think there are a lot of patients who would beg to differ. It is superior for several reasons. It has immediate effect, and you can properly titrate it. You can stop when you've had enough. Now, perhaps vaporization would be superior, but just recently there was a medical study which indicated long-term effects on lung usage of lung capacity of long-term smokers does not reduce their health in any way. That was a 20-year study of moderate to heavy smokers. And in the 1999 report from the National Institutes of Health, they also said that there have been shown no long-term harm from the effects of marijuana use. As for the physician-patient relationship, I wanted to comment on Bill Verda's position, and I understand that doctors might want more clarity in this, but the goal to me is not the viability of the physician-patient relationship. The goal is the viability of the patient, and that the 55 or so physicians who are writing recommendations have no problem understanding and staying within the rules of what that is, at least most of them. And perhaps what we need is for the medical community to actually set standards for this, rather than put their head in the sand and ignore it and say there are no standards. That's what's going on now. So in my last 5 minutes, I'd like to tell you about what's going on in my life. Having a firm with 4 lawyers that is exclusively dedicated to marijuana law, you can imagine we hear from a lot of patients and a lot of caregivers. And the first year, it was mostly information. How do I become a patient? How do I become a caregiver? How do I find a doctor? What is the law? What's about an enclosed lock facility? All that. The second year, it began with, the second year was mostly court cases and people concerned about the effects, the negative effects, all these court cases becoming so restrictive. What can we do? And this last year, with the Attorney General opinions and the even more restrictive cases, and then the compassionate apothecary case that basically outlawed patient-to-patient sales, if you will, or sales, period. And that's a whole nother lecture. But with that, patients were not finding access. And so they were approaching us saying, what can we do? And so I, of course, said, write your congressman. You know, this is a federal law needs to be changed for federal scheduling. And they said, well, we did that, and Debbie Stabenow sent us the same form letter she sent us last year. And I said, okay, well, you can go to court and protest. And they said, well, when we do that, then the judge questions us about holding up these signs about jury nullification and whether, you know, and questions the jurors about whether they've been spoken to and all that. And we could sue, but you know, that's a long, slow process. And there are a couple of lawsuits that definitely should be brought. One for the state failing to issue the report for the third year in a row that's supposed to list the number of patients, physicians, conditions in each county and all of that. Secondly, for failure to establish and implement the committee that's supposed to investigate requests to add new conditions like post-traumatic stress disorder for our veterans and anxiety and depression and other conditions like that, which were requested 3 years ago and the state still has not acted on them. Those, I think, are fairly easy suits, but I don't know that that's going to really solve the problem, even if and when we win those. And the fact that the cards are being issued 6 months late, roughly. When they're supposed to be issued within 20 days. So with that, people said, I've written my congressman, I've protested, and I don't know what else to do. And so we said, well, we're going to start having some Monday night political discussions, and we did that in October. And the short of it is, what we have now, what came out of our Monday night political discussions, is a petition to repeal prohibition for adults 21 and over in Michigan. Now, I've been asked the question, does this legalize marijuana in Michigan? No, it doesn't, because there's still a federal law against marijuana in Michigan. This would just repeal the state prohibition. You could not be charged under state law. They could not take you to a state court if you're an adult 21 and over, and as long as you're not providing it to minors or driving while impaired. And so we need 323,000 or 332,000 signatures in Michigan in the next 5.5 months. James Campbell over here is the treasurer of the campaign. You can give checks to James, payable to the Committee for a Safer Michigan. And with the people who are volunteering and working on the campaign, please raise your hands so that people can see roughly how many folks in this room are already involved. And thank you. Thank you all very much for all of your work. We are doing this as a volunteer effort. The medical marijuana law that we have in Michigan was funded by the Marijuana Policy Project. Thank you, Karen, and Dan, and all of you. And at the MPP gave us $1 million. Well, they didn't give us, they used $1 million to pay petitioners mostly to fund that effort. This effort is not funded. MPP, as you've heard, is concentrating their efforts in other states. I think mostly they're concentrating on Colorado this year. And we've not gone to MPP for funding. We've not gone to any major organization for funding. We believe that we can do this. With 150,000 patients now in Michigan who are mad as hell, we can do this. But for the way that the courts and the police and the Attorney General are dealing with this law, we would not have the energy and momentum that we do. A year ago, I had no plan to do anything like this, but basically it's been forced upon us, and we expect that we will be successful. However, there are other benefits as well, which is there's pressure on the legislature now. They know that, you know, the more wrong things they do, the more volunteers we will get. Likewise, I was sitting in the second row during the Supreme Court hearings 2 weeks ago, and they also should be feeling the pressure from the patients. And 3 of them are up for re-election this year. So it's going to be a really interesting political year. I'm I'm at the peak of what I ever wanted to do, which is the conjunction of law, politics, and marijuana. It doesn't get any better for me. So thank you all very much. I appreciate the opportunity.
Thanks, Matt. That was fantastic. To get the questions started off, I have kind of a question I want to ask of all the panelists that I think will maybe highlight some of their thinking on this. So we have the MMMA as it currently stands right now with, of course, tremendous uncertainty over patients' rights, dispensaries, et cetera. We've got the legislation pending in the Senate and House that some would say would eviscerate a lot of the protections of the MMMA. And then, of course, we have the petition drive, which would take marijuana law reform a step further in the state of Michigan. So my question to the panelists, and perhaps they'd answer this in the order that they spoke on the panel, is basically, I'd start with Neil. What advice are you currently giving potential patients who are seeking marijuana for medicinal purposes, given the uncertainty with the MMMA, the potential for registries under the new legislation, as well as the potential for further reforms? Are you basically advising clients to work within the current system, taking the risks that are available, or to continue to basically seek their product outside of the legal system? For Bill, the question will basically be about medical providers, and I'd like your gentleman's thoughts as well.
Can I answer from here?
Yes, please.
I typically don't end up giving advice to patients about how to seek treatment. But because I anticipate that a lot of them will end up potentially charged or investigated, this is what I tell them. If you're going to see a doctor, take all your medical records. You have to, in some way, I disagree with Bill, you have to take control of your own medical history. You have to take control of the doctor-patient relationship. Because you know what can happen if you're a patient and the doctor doesn't do the sort of investigation or analysis or assessment that you hear doctors and other critics, I'm not saying you're a critic, but other critics want doctors to undertake. So go to your doctor, this is what I tell my clients who ask me. I said, you go to your doctor and talk to him. Get an initial analysis. Take your medical records. Tell him or her to get your medical file. Tell them to do a full exam. You don't want a mill or certification or certification mill examination. And when you go there, say, I want to come see you again. And I want you to actually do a full examination. I want you to explain to me the benefits, the strengths, and the weaknesses of using marijuana. How should I take it? Do you have an opinion about that? And if the doctor can't give you an opinion, or they just want to charge you for that one-time assessment and write you a certification, turn around and go to somebody else. Just like you would any other doctor who you go see, if you don't like what they tell you, or you think that you're giving you shoddy treatment, you can turn around and walk the other way. I believe that any patient in this current environment knows that you need to go to a doctor or should go see your doctor more than one time. You should follow up with that doctor after he or she certifies you. You should go back. And that may cost you money because those doctors sometimes charge per visit, but you should go back and say, listen, I want to follow up with you. And by the time, God forbid, you are charged or you encounter some legal problem, you'll at least have some file that'll show repeat visits, that'll show analysis, advice, discussion, pros and cons, the sorts of things that doctors are supposed to provide for their patients. If you go to a mill and complain that you have a injured pinky or that you stubbed your toe and you want marijuana and you pay $150 for a certification for that one time and you walk out, quite honestly, you're inviting yourself to be examined by what is proven to be hostile police officers, hostile prosecutors, and an unwelcoming court. And I would say, at best, a dubious court. So you don't have to do it. That's my advice.
Bill, what are you telling your clients, the doctors? Do you find that most of them are willing to offer basically the certificates?
What I find is the ones that I've talked to is the majority want to stay out of it, and that was kind of the point of my presentation, is that I don't disagree with Matt or with Neil, that physicians to cover the patient and to cover themselves, have to have a lot of documentation and do what they normally do with other patients. What I was pointing out is that they're not required to under the statute. That's not my advice to them to not do it. My advice is treat this patient like every other patient, and if you believe that they can benefit from this, the more documentation that you would have, the more support, certainly for the patient, but also for the physician when the licensing board comes and knocking on the door. My point I was trying to make is that, yes, certainly this statute is primarily for patients, but the process needs a physician. They're integral to the process, and if the physicians feel that they're at risk because of the ambiguity in the statute, as a practical matter, they're not going to do it, and that's what I'm finding.
Gentlemen, actually, maybe Matt starts out, and I'll have Kevin finish up on this one. Matt, given everything you're looking at, I mean, you wouldn't be pursuing and putting a tremendous amount of your time and attention into the ballot initiative if you thought the MMA was working for patients. But despite the fact that it's flawed, are you advising patients to follow the MMA or basically?
Yes, I am. While your mileage may vary, there is some protection with having a card, certainly. And I tell people first approach your own personal physician, your regular doctor, and some people are successful there. If not, try to educate the physician, provide information to them, and then if that doesn't work, go to a clinic. But having a card is better than not having a card. As a police officer said to me one day, that it's not that hard to get a medical marijuana card in Michigan, and anybody who smokes pot is an idiot if they don't get one. And that was from a police officer. So, you know, they say anything in the back room, but so.
Well, actually, that tees it up perfectly then what I was going to ask Kevin, except you phrased it far more succinctly. Do you think that cop is right?
That people should get. I mean, you know, clearly, I mean, maybe.
We know your views on general marijuana policy, but given what the law is right now and the desires that some people have.
Yeah, clearly anybody with the willingness to get a card for any condition seems to be able to get a card. So I would say, sure, if that, you know, that cop is giving advice to anybody. What I think is a shame in this is that you have lawyers and law firms talking about an issue of medical and scientific importance, and I don't understand why we would not, you know, follow this same kind of, you know, we would definitely not follow this route if we were talking about any other medications, since this one is loaded with all kinds of cultural and other kind of baggage that we mix up medical with legalization, with decriminalization, with anyone over 21, with only if you have a chronic illness. And I kind of wish these issues would be separated, because it should be the scientists, not the trial lawyers, talking about medicine.
Well, I'll tell you why we talk about it. We talk about it because the government ignores it. And what's happening is the federal government, you got 63% of the population in Michigan that says that medical marijuana is something that is beneficial and should be left alone. Hold on. So someone comes down from Washington, D.C., or wherever you're from, and you come in and you want to tell us that we voted for something, but your law is superior. And all I would tell you is if you don't like what we're doing in Michigan, go back to wherever you came from and do it there.
All right,
so the lawyers are dealing with it because you're not. And so you know what happens? Lawyers are often looked at as the vermin, we're the scum, there are a million jokes about us, but you want to know something? When there's a problem, it's guys like me, it's guys like Matt that people turn to when their rights are being trampled on, and it's guys like us that in the end are the ones that people ask for help. So clients ask for help, and I give it to them. What are you doing for the patients that need it?
I'll tell you, let's be clear.
Well, no, have you ever represented anybody in court? Have you ever helped a single individual
he's
by
not
name?
a licensed attorney. Let's get his perspective here,
I'm not going to get
Kevin.
into a courtroom showdown with you, sir, but I would never say, and I didn't ad hominem attack you or, you know, half of my friends are either lawyers or doctors. So I'm not attacking. What I'm saying is that I am also not qualified to say what medicine is, and neither are you, and neither are most people, neither are 63% of voters. It's the scientific process that determines medicine. So I'm simply arguing that process should go forward as it is, and I'm not.
But we turned it over to doctors. We turned it over to the doctors. It's the government that is scaring doctors into not certifying. It's large medical groups where doctors work out of affiliations with either hospitals or hospital groups or malpractice carriers that are intimidating doctors into not writing certifications. That's what's happening.
I'm not getting in the way of a doctor-patient relationship. I think a doctor could say whatever they want, and they're protected by the First Amendment to say so to their patient. I'm talking about a medicine that's approved for dispensing.
The problem is that every
We're gonna let
time
Matt, and
we
then we're
have
gonna
a
open up to
medical
questions.
study, the medical studies all say it's not harmful, it's not addictive, it's not dangerous, it serves people, and that research is ignored. There are studies after study after study proving the medical value of marijuana, and the government continues to ignore them. That's the problem, that there is no truth here.
Okay, great. Let's get audience questions here. I'm gonna point to people in the audience, and if you could wait a moment patiently for a microphone to arrive so that the folks upstairs can hear the question, I'd appreciate it.
So I got a question for you. Do laws create rights? Do laws create rights, is my question. Any panel member can answer.
Well, the Redden case
I'm just a
said-
dumb trial lawyer, so no, yes, laws create rights.
What about the city attorney or the attorney? Do laws create rights?
I think laws recognize rights, and our Constitution says some rights are inalienable, right? So
Well, is the Medical Marijuana Act a law?
It is.
And if people follow that law, do they get protections of that law?
In Michigan, if they follow it to the T, they get protections. Michigan, some protections are given, and the state has said that if they're not protected if they don't follow it. What the state has said on some areas is that the law is silent, and therefore the laws that previously existed are being followed.
So if you follow the law, the black letter of the law, should they be for those protections? Right? Medical Marijuana Act? Is it a criminal law?
Understand that there are laws on the books that have marijuana illegal. Those that have not been eradicated by the statute.
I understand that, but this law's most recent time, this law in some aspects trumps those laws by its language, correct?
Not correct.
How is it not correct?
Because of what I said before,
But what you said before contradicts what's in the language of the statute. Is that not so?
If I could interject here, there's no dispute. We've got a really complicated and conflicting legal landscape. There is no one law dealing with marijuana.
My final question is this, though. This bona fide physician-patient relationship, do you have health insurance?
perhaps.
Thank you. You ever go to an urgent care? Have you ever gone to an urgent care?
We got to move on to some other questions. I'm sorry, sir. Okay, we will. We'll get to another question then. Thank you, sir.
Thank you. I had a question to Mr. Verdes, is it? You mentioned standards of care. Are they in the Michigan Public Health Code?
No, the concept of standard of care is a flexible one. They're not set in stone because it depends on the circumstances of the case. As I indicated, the definition is what a reasonable doctor would do, what a physician of ordinary training and skill would do in the same or similar circumstances. So that is judged on a case-by-case basis. And that was what the point was, is that when we've got a statute that says a doctor can be sanctioned for failing to follow the standard of care, the question that it begs is, what standard of care and who decides that?
Is there not also a definition in the medical standards as to a doctor-patient relationship? Is what constitutes it, or what constitutes a bona fide doctor-patient relationship?
Well, there's not in that particular language. There are statutes that talk about the duties if a patient-physician relationship arises, but the statutory language of the MMMA just simply says a bona fide patient-physician relationship without definition, and that's not defined elsewhere.
But wouldn't it be better to put it in the Public Health Code than in to change the Michigan Medical Marijuana Act?
Well, as I understand it, I'm not a constitutional lawyer, but as I understand it, since this was a voter initiative, this can't be simply changed by Congress. It needs a three-quarter majority in order to change the language of this. I believe that the statutes are being proposed because the argument is that we're not changing anything. The Congress says we're not changing this because it's not defined, so we're defining an undefined portion. So wherever it goes, again,
I don't have a stake in it. I don't care one way or the other. But what I'm saying is that if you want physicians to be involved, right now, the physicians are reluctant to do this, and the reason is because of this uncertainty. So whether they do it in the health code or they do it as a amendment to this statute, my point is it should be defined.
Thank you. Ma'am, I saw a hand up front. Just wait a moment for the microphone.
I have two questions. First of all, Mr. Sabat, is that your name? You talked about the money-making machine. I'm sure you're quite aware that in Michigan, our asset forfeiture laws don't require law enforcement to obtain a conviction or even really charge anybody with a crime. And our multi-jurisdictional drug task force has just received $7 million of federal grants to go get drugs, despite the fact that we have less than 30% arrest rates for rape and murder in Michigan. So as far as making money, I see the folks that go get the drugs, 80% of which is marijuana in Michigan. Those are the guys making money on the backs of the people that thought they were going to be safe. So I think that's disingenuous, at least, to say that there's a money-making machine here when law enforcement is directly profiting from doing this.
One question at a time, please.
I wasn't necessarily, I'm not coming in here as an expert from Michigan, and I was asked to come and give a policy perspective. When I'm talking about the money-making machine, I'm talking about in places, and I'm not familiar with Michigan as much as I am with California or Colorado and other states that have allowed, dispensaries with pretty wide open rules. There's been a clear profit motive when you look at what is sold. I mean, what's interesting actually from an economics and policy point of view is that the price of marijuana, even in California with all the dispensaries, has stayed the same. It's virtually identical in the dispensaries as it is to the underground market, which was actually surprising when you look at that. So the profit margins are high. When we're talking about asset forfeiture, I mean, I think that's a totally different issue. I'm not necessarily familiar with Michigan. My opinion on asset forfeiture is that you actually should obtain a conviction, and it should be a pretty serious case, and to warrant that. Otherwise, you open yourself up to corruption. You're opening up yourself to having police departments focusing on cases they may not normally focus on. So I'd be with you. I'd probably meet you halfway on that one.
Sure.
And then I also am here to challenge the concept, and I'm glad that all these attorneys in training are here, about health and about medicine and about who determines what's medicine and health. This is plant medicine, marijuana is. I'm American Indian and white, and I don't go to a doctor, I go to the medicine man. When I go to a physician, it's for a diagnosis so that I can use plant medicine. I grow echinacea, which is a plant which is used for healing. I use homeopathic remedies. I give birth at home, which is legal and safe in Michigan. Home birth folks do not sue their practitioners as much, and they have less complications. And likewise, all of this scientific, it's like Greek to me, all of the scientific talk that you guys are talking about, that's fine for the folks that want to go to a pharmacy and obtain their medicine, that want to see all the sort of testing that proves whether or not this works. But as a woman, as a healer, and remember, women have been the healers since the beginning of time here on this planet for our families and ourselves and the earth. But as a woman, I quite personally just want to see whether or not it works, whether or not it's harmful, and I listen to my body and my children's bodies when they respond to something. And I would be mortified to see bona fide relationships defined in this way because it's outside of the informed healthcare framework, which means that you inform yourself about your biology and about the medicine you're taking and the choices that you're taking. Thank you.
Just so you know, I think that a lot of lawyers, people who are critics of the Medical Marijuana Act or of proponents of it, they kind of dismissively refer to those of us that are advocates for patients and caregivers as patients or potheads. Not that it really matters, but I'm not a patient. I'm not a caregiver. I don't use marijuana. I never have used marijuana. My grandparents were Holocaust survivors. They passed away 3 years ago. And I believe that anything that alleviates suffering in any way is something that people should have access to. And that's the reason why I support medical marijuana.
We have a question up on the balcony. I want to make sure to get the folks up top.
Yes, the federal government applied for a patent for the medical use of marijuana. The patent office granted that patent. So how can the same federal government deny any medical utility?
If I understand, I think that's confusing two different things. I think the patent, if we're talking about the same one, we may not be. is the patent on Marinol and on a certain defined substance. Oh, hold on. So that's what I'm familiar with, because there's a patent. I'm not familiar with that other patent. So
Is the question, why is the federal government acting inconsistently? I think that begs the question. It's the federal government. It acts inconsistently all the time.
I'm going to get this gentleman over here, if somebody could bring a microphone to this side of the room.
I would agree.
Thanks, Neil.
I feel like we should have like a Ford motor vehicle, and I should be like a stunned, one of those stunned Ford drivers.
Sir.
Well, I'm sorry to keep picking on you, Kevin, but the other three are kind of all in our favor on the topic. But you were discussing that marijuana is not a medicine, that in order to be, pharmaceutical grade medicine has to be approved through the FDA process, and that there's actual chemicals in it that are the actual medicinal side of it. And I'm not arguing that fact at all. I mean, in order to be accepted in a medical facility, it needs to be regulated, taken care of. But, I mean, you brought up the fact Sativex. In order for Sativex to actually exist, they were given the permission to grow over 60,000 plants. And these plants have now been cloned so that you standardize an exact strain. So how, me as a caregiver, or how is somebody supposed to standardize the strains to be able to figure out what medicinal qualities are in there when if I grow more than 100 plants, I'm looking at a minimum of 5 years federal imprisonment,
I think the answer, I don't think you're going to like it, but the answer is that a quote-unquote caregiver is not supposed to do that. Just like you're not supposed to grow willow bark and extract it for turn it into aspirin, and just like you wouldn't be qualified, nor I would be qualified, to take opium and make morphine out of it. So there's a way to do it properly in a lab and to standardize it. And for Sativex, if I can answer, and then I'll let you just respond. I'll just finish really quickly. Thanks. That Sativex it is a plant, and it's just like opium and just like willow bark. And so what they do with Sativex in the UK is they grow it in a certain undisclosed facility where they have standardized it. It's the 1-to-1 ratio. It's been tested in the lab, and that is what's replicated and turned into this mouth spray. And so I don't think we would ask you or ask certain people in this room to do that. Okay.
The only approval through the government for growing plants is at the University of Mississippi, and they've been growing there for 40 years, and they haven't come up with what GW Pharmaceuticals did in less than 13.
So two things. GW Pharmaceuticals, right, so that's in the UK, and that's where they did that. At Mississippi, I mean, and for those who've been there, we know that there are all different kinds of strains and all different kinds of, so there's some that have high THC, low THC, high CBD, low CBD, and all the other constituents that we talked about. There are different strains, but Mississippi is simply a holding facility for that. That's not a pharmaceutical company. So we wouldn't ask University of Mississippi nor expect them to produce those medicines based on what they're growing. That is for researchers, and as I said, there are researchers doing that as we speak, to apply to obtain the different kinds of marijuana strains they need from that facility to then turn it into medicine.
Great.
Yeah, it's still meant. And it's still meant for research. That's my point. It's not meant for medication development.
No, I think he means that they grow plants for research for testing, not research for development of new products. And just like you would do research on automobiles for safety and you do automotive research to develop new products, there's certainly different types of marijuana research that can be done.
Obtain that also if they would like to. By the way, the pharmaceutical companies, just very interesting, haven't been running towards marijuana-based medications. It's like, not really. No, they have, the big ones have not. GW is a tiny pharmaceutical company in the UK. So there's not necessarily this big rush to turn these medications, because they just don't see there's much future in it.
Federal government.
I would disagree.
I got to get to a few more questions here before we wrap up. I saw this hand up front, and then I saw one in the back, and that'll probably be all we have time for.
I want to know why the government presumes that we have to use synthetics. Like you say, the FDA makes these synthetics, and please let me finish my question. For people like myself that cannot use pharmaceuticals, the FDA makes pharmaceuticals for people your size and then gives them to people my size, and it's wrong. If they made medication for women or respected the right that this is my body and I'll put into it what I please, and that people will inherently seek out what cures their ailments regardless of what the government rules, when do you see this might be for all of you, when do you see the government getting back to caring about violent crimes, sexual crimes, and actually helping people?
Matt, you probably have an optimistic answer to that. The rest of the panelists, I'm not expecting a highly optimistic answer to what was probably more of a rhetorical question.
Well, it goes to, we have to exert political pressure, and you know, the government is not responding because they're not feeling the pressure. So go to repealtoday.org and register and help us volunteer to legalize marijuana in Michigan, or sorry, repeal prohibition. And the other thing about the federal government does produce marijuana theoretically for testing, but the only studies that they ever approve are studies directed toward proving abuse. They've never approved any studies directed toward proving the medicinal value. And so
that's true. We have this, in fact, so that's the big, I think, myth out there, is that there's only on the negative effects. Yes, there are studies looking at the negative effects, because there are negative effects, but there are also studies.
Where are those government studies looking at the health?
I think actually if you go to Kevin's website, you'll find a lot of the information that he's referring to. I'd ask that you give our speaker the respect of looking at the information he's referred to rather than shouting back at him. Thank you. I have time for one more question. Woman in the back, please.
First of all, I'd like to take a moment to thank all the speakers for coming in today. And I guess this question would be directed more to Mr. Rockhind and Mr. Abel. And that is, would the Medical Marijuana Act be considered a success if it does not give patients access to the ability to smoke marijuana itself, but rather gives patient access to derivatives of marijuana that can treat their symptoms?
Question. I'd love to hear an answer to that question, actually, from both these attorneys.
Derivatives such as?
Derivatives possibly being something like Sativex or something like a pill form of THC.
I would answer the question with no. I would consider the Medical Marijuana Act to be unsuccessful if patients are forced to use either Sativex, which is not approved, or Marinol, which is a pill. And let me tell you why. A pill is just a certain form of delivery system for a drug. And in order for the delivery system to work, you have to swallow the pill, your body has to actually digest the pill, and then the drug, whatever your body, the bioavailability of that drug, then has to actually make its way into your bloodstream, and then eventually make its way into whatever part of your body you're using or desiring to heal. The problem with pills are that people who have gastrointestinal disorders or Crohn's, or have a difficult time even swallowing or processing food, cannot take pill form medicine. They literally will just vomit it up and they'll get nothing out of it. I have a brother-in-law who suffers from Crohn's. It is debilitating. My father-in-law is dying of diverticulosis, which is irritable bowel syndrome. And I can tell you that the ingestion of foods or any substance or pill is completely ineffective. So I would consider the Medical Marijuana Act to be I don't want to say failure, but it would be a failure if patients weren't allowed to use marijuana in the way that they feel that it best helps them. The last answer I can give is that the cost of medicine is outrageous. I'm very fortunate. The law has been very good to me, and I'm very blessed that my family and I are able to afford health care. And my employees are covered with a health care plan. My story is not the story of everyone else. Others are rejected from health care policies or don't have health care at all. And if they don't have health insurance, the cost of medications and pills is extraordinary. I think it's cost prohibitive. The cost of seeing doctors is again cost prohibitive, and many doctors or hospitals won't even see patients unless they have insurance. The first question they ask you is, who's your insurer? So for a lot of people, believe it or not, naturopathic or marijuana, or marijuana, be it eaten, smoked, ingested, inhaled, is the only remedy they have. And as I said before, I consider the Medical Marijuana Act a success if it has helped any patient, even if it's just one. And I'm sure that it has, but it can be even more successful than it is now.
So, Mr. Rockhind, you would not consider it a success if somebody could get a Sativex delivery system which did not require swallowing?
No, because here's the other issue with Sativex, and I'm no expert on it, but I believe that I'm competent enough to talk about pharmaceutical companies. And again, I'm not someone who believes there's some big conspiracy against big pharma, but I do believe that they're in it for profit. And so when they manufacture a drug and they then get it approved, we have seen nightmares and catastrophe that has resulted from approved medications that a year or 2, 3, or 5, or 10 years later are proven to have been more harmful than they were beneficial. So here's the thing that it's an excellent question, and I give you a lot of credit for asking it, but here's the question. Again, and I ask anybody, why is this such a big deal? I mean, the presidents have smoked marijuana. I think I might be the only person and probably in the room not to have used it. So here's the thing, if I can see the wisdom of it and I don't use it, then heck, just let people do what they want to do. I'm not saying like peace, love, and get high, but look, if people want to use it and that's what makes them happy and it gives them relief from the rigors of life, then God bless them. Go do what you want to do.
And you can thank Mr. Verdes for training me, for asking the question, as I have the honor of being able to be a clerk for him.
Oh, it was a good question, and I'm going to give you credit for it. I'm not giving Verdes credit for anything.
Matt, Kevin, did you guys want to respond to that about the effectiveness of the MMA? When
My first response is objection hypothetical. But that's a hypothetical question, and okay, you haven't had evidence yet. All right, but I think that it depends what lens you're using to view this. Whether I believe it's a success or not is kind of irrelevant. My clients who've been arrested, not so much. My clients who've not been arrested, they feel it's been quite a success. So it depends if your ox has been gored or not, is my answer.
Great. With that, we have to wrap up. It's after 4 o'clock. I appreciate the audience's patience and participation, and I'd especially like to thank our panelists for dealing with a really contentious issue and sharing with us freely their time today. Thank you.
Take it on the road or something.
Thank you, everyone. Thank you, Noah, very much. Thank you, panelists. Thank you, Professor Sedler. I want to say that please join us in the atrium for some evening refreshments. And I also want to conclude with saying thank you very much to the Law Review, the executive board, all of the staff, special events here, Jeff Block, and all the media services guys, Anne Marie Eliota for helping. Everyone's been a great help, and it's been a success. And I'll be out in the lobby if anyone has any questions. Thank you.
Or just wants to thank her. She'll be out in the lobby.
Thank you.
Thank you. Oh, hopefully that was good. So, good. Not academic, but
done and done.
Hey, thank you. I appreciate that. Thank you. I'm actually a new Oh, good for you.
And that is going to conclude our coverage here today of the Wayne State Law School, it's Wayne State University's Law School Symposium. It's the Marijuana Symposium. Today is 27th.